Good evening and thank you all for joining this webinar. Hope you all are staying safe and keeping good health. I am Rachna Kothari Doshi, Associate Director with RBSA Advisors. I look after the dispute support services at the firm, including other areas of valuations. I welcome you all to this webinar hosted by RBSA on damages and loss assessments, issues and challenges. In this webinar, we wish to cover various aspects of loss assessments, damage quantifications, legalities around the contract, experience and role of financial experts. To take us through this, we have an eminent panel today with us that includes Vyapak Desai, Raj Panchmatia, Rajiv Shah, and Ravishu Shah. Vyapak Desai heads the International Dispute Resolution and Investigation Practice at international law firm Nishit Desai Associates. A senior attorney with the firm, Vyapak specializes in cross-border complex disputes while also leading the corporate and securities practices in the past at the firm. Vyapak is also a trained mediator and an experienced arbitrator in international commercial arbitrations, is co-chair counsel of MCIA, and has been listed on the panel of various arbitration councils like SIAC, AIAC, and LCIA. Raj Panchmatia is a partner in the Dispute Resolution Practice Group with Cate and Company, with rich experience in dispute resolution and commercial litigation, both at the domestic and international fora. Raj's key practice areas are infrastructure, private equity, mergers and acquisitions, securities, defense, shipping, power, and hospitality sectors. He's appointed on the SIAC panel of arbitrators and HKIAC list of arbitrators. Rajiv Shah is Managing Director and CEO of RBSA. He leads the valuation and advisory practice of RBSA, a mechanical engineer, MBA, and a chartered financial analyst by qualification. Rajiv has close to 2 decades of experience. Rajiv has been involved with major disinvestment assignments on behalf of Government of India. He has also handled complex dispute cases in his capacity as an expert witness at various legal forums. Ravishu Shah is Managing Director with RBSA and has a post-qualification experience of over 23 years. A chartered accountant by qualification, he is also a member of Associate of Certified International Investment Analysts and Institute of Chartered Financial Analysts of India. Ravishu was a part of working group of ICAI for formulation of ICAI valuation standards and is also a speaker at various forums, including ICAI, WIRC, Chamber of Tax Consultants, including others. I thank the panelists for joining us today for this webinar. Participants having questions can pose their questions in the Q&A window during the course of the webinar. We shall try to address the same at the end. Now, to begin with the webinar, generally when two parties are at a dispute, they fight for a number. The assessment and quantification of that loss or damage includes various legalities and financial aspects. This process also takes its cues from the underlying contract. So my first question is to you, Vyapak. What, according to you, are important pointers in a contract that determine the extent of loss or damage that can be claimed in the eventuality of a default or a non-performance of a contract?
Sure. So thanks a lot, Rachna, for this webinar, and thank you, Rajiv, Ravishu, and the RBSA team for inviting me for this. Considering the importance of the topic, as you rightly said, we have more than 500 participants on registering on this webinar, which shows that you are on the right track so far as this webinar is concerned. People are eager to know. And more importantly, in these times where the economy was anyways little bit going downwards, at least the end of 2019, early 2020, while we were showing some good signs as well in terms of recovery. But the COVID situation has made those possible downturns even more steep, and therefore I think issues related to losses, claims, damages, voluntary or involuntary breach of contracts uh, is are going to be a commonplace once people actually start going back to their business and look at their commitments and obligations in the contracts. So I think definitely this is something which is very relevant at this stage. Coming to the topic itself, right? I think we are talking about contractual damages and the compensation for the loss suffered. So this is broadly enshrined in our Contract Act. Uh, Everyone possibly on this webinar listening would generally be aware of Section 73 and 74 of the Contract Act. 73 talks about, in a loose terms, unliquidated damages, where you have not specified the amount of the expected loss on any promise being broken or any breach being committed under the contract. But there are two or three important aspects of the Indian Contract Act which are not very unusual, or I would say they are also similar to many other common law jurisdictions. Uh, while there are nuances between the UK law or the US law on some of those aspects, but broadly the principles are not very different. So I think when we talk about assessment of losses, particularly on under Section 73, the first and the foremost aspect which comes to anybody's mind is that, one, it is a compensation, right? And you only compensate for loss or damage which is caused and naturally or in usual course arose from the breach, which means, as the law prescribes, any remote or indirect loss are not allowed under the Indian Contract Act. So I think this is where the biggest discussion happens as to how do you calculate those losses. First exclusion is no indirect and remote losses or damages are allowed under the Indian Contract Act. How do you exclude that, or how do you ensure that you don't include that? And we will discuss some of the examples as we go along on this webinar. But this is one criteria, and I'm sure Rajiv and Ravishu will have their thoughts on how the financial models apply in those situations. But that is one important criteria. The second criteria is mitigation of losses. Even if there is a breach, has the party who has suffered the breach and not committed the breach taken all the steps to mitigate that breach? Uh, it may be different in cases of usual sale of goods or provision of services, short term or long term, and it may be very different in a joint venture shareholder situation, and it may be completely different in a construction infrastructure project. But mitigation of loss is the second important criteria to ensure that you don't go beyond what is prescribed under the law. And the second aspect is, of course, Section 74, which is liquidated damages, where you obviously have to prove the breach, but you don't have to go further than that to prove the actual loss, so long as the amount prescribed is not considered as a penalty. uh, you know Typically you don't have a role of RBSA, particularly in that kind of a situation. So
Yeah.
that's one aspect of the Contract Act. The second aspect of the Contract Act is losses which you recover through contract of indemnities, right? And that becomes a very strong tool, because unlike a damage clause, there are 3 or 4 very, very pertinent differences in a contract of indemnity. The first is, so far as damage is concerned, you can only claim it between the parties. In sense, uh, if there is a action or inaction on part of a third party resulting to any loss, you can cover it in an indemnity claim, but you can't cover it in a damage claim. Second, you can even claim indemnity before going out of pocket, which is not possible in a damage claim. You have to actually go out of pocket and then only reclaim it as a loss or damage. Third, there is much more wider uh, applicable methods where you can include indirect and remote losses in a way the contract is written for an indemnity versus a damages. And fourth is obviously that indemnity is more like liquidated damages, where you don't have to go full blown into actual calculation of losses. I think with that broad background, the only other aspect that one needs to take into account from a legal perspective is the limitation of liability clauses, where if the contract specifies any limitation of liability and excludes certain claims of damages, then those are also to be considered at the time of calculation of damages. So I think that's what my initial thought would be, just to put this background as part of our discussions, and we'll make it more practical considering the different examples and sectors that we may deal with as we go along. But Raj, if you have any thoughts or any additional point, feel free to come on this as well.
So no, I think you covered most of the points that need to be placed as a backdrop to this discussion, and I think we can now probably start on the practical aspects.
So thank you for that background, Vyapak. And moving on from there, Raj, how critical do you think is the role of a financial expert during the dispute resolution process? And would you necessarily make a differentiation in that role under a litigation and an ADR, meaning an alternate dispute resolution?
So I'll tell you, the role of a financial expert in a dispute practice today is extremely important. Traditionally, we've seen that it was an in-house person in our organization who would probably help a client build up its financial claims, how to compute his claims, how to compute his losses, and how to structure the claims that they want to make in an arbitration or in a litigation. Things have changed since then. We've evolved. The cross-border transactions are being seen regularly now, and in the cross-border transactions, we've seen more and more complex transactions coming into place, where the role of an expert who can understand and explain and help parties to formulate their claims in a way, if there are cross-border disputes, and then they can help them formulate the claims in a way that can be presented before the tribunals. We've seen valuation issues that can be used very effectively when we get a financial advisor on the board. Quantification of claims. We've seen sometimes in an arbitration, it becomes extremely important to quantify your claim in a correct manner. You don't want a situation where you have double counted a claim, or you've not counted a claim correctly, because these issues happen when you do it in-house, and sometimes you miss the experts there. So I think it's a very, very important to have them. We've seen in cases of delay and damages claim, to compute the delay how much delay can be attributed to a particular issue, and how a compensation or a damages claim can be built upon that. Something that's very, very important. And I think it's very important in scenario, especially for, say, an arbitration or a litigation, to bring in an expert at a very early stage, rather than bringing them at a very late stage only to give evidence or give an expert report. Because if an expert is helping you even to at the time of quantifying your claim in your statement of claim or a counterclaim, it helps a lot even to the expert when he's stepping into as an expert witness to justify the manner in which the whole claim has proceeded in your pleadings. So I think, to my mind, it's a very important role that an expert plays. And in today's day and age, while it's slow starter in India to have an expert involved in any disputes or in litigation matters, but I think now more and more we are seeing experts being engaged in many complex disputes now.
Maybe if I can come here for a minute, Rachna, I completely agree with
I
Raj.
was very keen on this, Rajiv, because this is an area of practice which needs a handshake between the lawyers as well as the financial experts. So,
See,
love to
often,
hear your perspective on this one.
yeah. See, I completely agree with Raj. See, often initially, the company will itself, the claimant or they would have their own set of people ascertaining a claim. And at that stage, I do not know the level of expertise that they have, but the tendency is to claim a very, very large number or to counter claim a very, very large number. And therefore, sort of threaten the other party to submission. So they end up claiming the earth and the moon. But eventually, when it comes to defending that, many a times it so happens that they have double counted many things and left out a few things. So we believe that maybe at early stage, if they come, then it is a more nuanced and a proper claim. Otherwise, which can stand scrutiny. Many a times, if these go for cross-examination or judicial scrutiny, at that stage, if the initial claim does not hold, that reduces the confidence of the jury and the judge on the whole process and your side of things. So if you have claimed things reasonably and if they make logical sense, then it is always better to maybe do it in a more structured, proper way. That's my take on the thing. I don't know if Raj and Vyapak have anything.
Yeah, if I may
Uh,
add,
Please,
no, I
Vyapak.
think if I may add a very simple point, I think earlier the situation was, uh, you know, most of the cases were built on, mental agony and goodwill rather than actual loss. And as I said, in a contractual claim, at the end of the day, your hands are tied as per section 73 and 74 of the act, however big is your mental agony and goodwill claims. So I think, and the second part was, people were not afraid of what Rajiv says of putting humongous numbers, because everyone thought that you will never be required to prove those numbers in your lifetime, considering the number of years it takes for a case to reach the damage hearings. With 30 million cases pending, there are lawyers in our field who have done their whole life, interim matters and never, conducted a trial on damage calculation. And they, not that they were afraid of, but those stages in the matters never came about. And therefore, even the jurisprudence as to how to calculate your damages in India is very, very minuscule. And some of the principles we still take into account based on, the other common law jurisdiction. So I think there were various factors which were playing out in our litigation system as to why the the expertise on the financial claims were not getting developed the way it is now getting developed. And thanks to arbitration and commercial court regime and the fast track process of commercial resolution of commercial disputes, that we are seeing that this kind of damage calculations are happening now on a very, very regular basis. And therefore the role of financial experts is only going to increase as we go along. So let me tell you, RBSA will never be out of work. So that's never going to be a situation with the way the cases are pending and the way the commercial disputes are at a rise. in this economy. While it's not a good point in that sense, but some of these issues may also bring in resolution, right? If you have the right financial expert, some of the claims may actually get settled, right? So I think somewhere it's not all about fighting or all about taking the disputes, but actually resolving it to its logical end. And in my view, that is where the financial expert's role is most critical, and not just because it's increasing disputes. So I just wanted to make a difference there, that this is more about reaching a resolution than just claiming an amount.
Sure. Raj, would you want to add a perspective there to what just Vyapak said in terms of the role and criticality, especially with the arbitrations coming in and alternative dispute resolution being the hotbed these days, and people not choosing to take a litigation route?
Yeah, so I think, as Vyapak also rightly said, the expert comes in as a right advisor who puts the checks and balances on the party's claims. So probably it will also show a mirror to the client that, okay, you want to claim 1,000 crore, but whether you can actually claim 1,000 crore, or whether what is the correct amount you should claim and what is something that is justifiable. It's one thing to just put a number, but also to probably justify the number that you are able to claim and receive. I have seen arbitrations where parties have put 1,000 crores, 1,500 crores. Then during the arbitration, suddenly they decide to bring in an expert, and expert will then say, I think we should reduce this claim down to 400 crores or 300 crores, because there's a lot of double counting in the whole claim. Uh,
Yeah.
and some of the claims are not even tenable in law. So it helps in also putting these checks and balances. The only thing that we have to keep in mind is when an expert is giving his report or an evidence before a court is different from what he's giving in an arbitration, because there somewhere I think a bit of a difference, and a lot of experts we've seen sometimes are shy of giving a report in a court, whereas some are more happy to give a report in an arbitration. So that's something that we are seeing regularly.
Great. So generally, what kind of expectations will a counsel have from an expert witness? I mean, Raj and Vyapak, the question is for both of you.
Vyapak,
Raj,
you
you
want
want
to
to
go
go
first?
first? Okay, I can. So I think I would put maybe just two or three uh, aspects. You have already said that the person is a financial expert, so I'm not even going into the aspect that expertise is the important criteria, because that's given. If the person is not a financial expert, then he or she is not in the job. So I'm not counting that as one of the criteria. But I think the biggest criteria that we look for, right, as counsels, is while the expert is appointed by a party, right, or a counsel, I think the biggest quality that we look at is the independence, right? Uh, because like lawyers, right, they are appointed by the parties, but from a court perspective, they are, first officers of the court and then for the parties, and they have to stand by the law as it stands. Similarly, I think the experts sometimes, are not able to maintain that thin line of difference as to whether you are party appointed witness versus you are a financial expert on a matter. And if a person is able to maintain that independence, I think that brings a lot of strength to the case, because then you know what you are presenting is what you are going to win, and it is not colored by something which is so uh, you know so outside the scope that even good claims get prejudiced in the process. So independence is the biggest quality, which obviously includes the conflict of interest aspect of it, because you can't get independence right unless you are free from conflicts, and there are not many standard rules or hard provisions on that, but there are a lot of soft issues around conflict of interest. So I think independence and conflict of interest I would put at the start. Second, I think uh, in addition to understanding the numbers and the financial reading of financial documents, statements, and balance sheets and other things, I think the second most important part is in understanding of industry knowledge. So sometimes when we choose an expert, uh, we actually go as to whether that expert is prominent and an expert in that industry rather than just a financial expert, because that brings a huge difference in the approach of calculation of losses and damages. And then the last would be basic understanding of law, because at the end of the day, you cannot go beyond the scope of section 73. And if they don't understand what is indirect loss or remoteness of loss or mitigation or things which are much more ingrained in the process of calculation of losses, then the whole process gets futile. So that's a 3-point message that I have while choosing an expert on a case.
So if I were to come in
Raj,
here, I quite agree that independence is the touchstone for good expertness, credibility that he brings in. If you have a credible independent witness, it makes that much task easy, even for the arbitrator to accept the testimony of an independent and a credible witness. Because as Dapak rightly said, sometimes you see an expert probably crossing the thin line and trying to justify these claims probably made by the party who's appointed him as an expert witness. I think if that's avoided and just as a practice and as what the correct process and procedures have been followed, and if the right formulas have been applied, and if he's able to establish that based on the credibility of his and his knowledge about the subject, because it's very important to have the knowledge of the subject. As Vyapak said, knowledge of the industry. And the third, I would say, is knowledge of the business of the business and for which he's giving it, because that's also very important, that how that business is run. Because unless you don't know how the business is run for a particular industry, you will never be able to understand the nuances of finance from there. And so if it's a financial, but I think that's also a very important point to keep in mind. Courts normally look at the expert's witness provided by both parties with a little bit of a circumspect initially. There'll be some cautious approach because the courts are not sure whether he's correct or he's correct. So it's possible that there may be a bit of a cautious approach, but I think if you have a good credible witnesses who are giving a testimony which is fair, independent, and correct, examining the correct propositions, I think it should be good. That's, I think, one of the key things that I would always see in a witness. And of course, how thorough he is in providing his calculations and his reports, because at the end of the day, his report speaks for itself. And if his report is not thoroughly prepared, not do all calculations in detail, or as is very superficial, then it can create a lot more complications. So one, his thoroughness is very important. Second,
Yeah,
if
dependability
he's
could be a challenge.
yeah, and the second that I see is also that when he's giving a report or he's giving a testimony, the fact he will have to probably rely more on what the fact witnesses have said, because he won't be able to introduce a new facts into the matter, right?
Yeah.
So we probably have to take the base of what the facts witnesses have already said, what accounts they have already produced, and based on those accounts that have already been produced, he's going to probably analyze the law, analyze the account, and that's a couple of things that I think.
Great.
No,
So thank you, Raj.
yeah. Yeah, please, Rachna, please go ahead.
So, taking cues from Raj's pointers, can I bring you in to share your experience and broad contours on the recent BCCI Deccan Chargers loss assessment and your experience during the cross-examination?
So I completely agree with Raj and Vyapak. I mean, the cornerstone of an expert. I mean, while an expert is representing and is paid by one of the parties, is essentially an officer of the court. So he should not first do anything which gives an impression of a bias, and he should not be seen as a biased witness. Because the first and the easiest thing for the counterparty is to destroy your credibility. So if you are seen to be biased or conflicted or supporting any one party, then essentially that is where your case goes for a toss, because then it is easy for a good lawyer like Raj or Vyapak to completely destroy you, because they will rip you apart in cross-examination. And so essentially you need to not just be impartial but act as impartial and to be seen as impartial. And as they very well said, that the report itself or the work that itself should be a speaking report. It is not that this is my view. It has to be based with logic, justification, data, references. Why? It has to be a speaking report. If this is your view, why is that your view, and what are the bases, what are the calculations? And so it has to be done in a very detailed, meticulous way. It cannot be just a statement of your opinion. It has to be backed by facts. It has to be backed by logic, justification, evidence. So here you have to prove that number, that damage or a loss or a value. It is your opinion, doesn't matter. You should be able to prove that opinion to any reasonable judge or to the lawyers. So this is more critical. So I'm completely with Raj and Vyapak on that. Now, coming to a recent case that we did was this BCCI Deccan Chargers. I mean, it has been very well covered in media and all. So this was a classic case where, and I can share the non-confidential part there. It was a classic case where BCCI terminated the Deccan Chargers franchise, and there was a huge controversy around it. Now, I am not a legal expert, so my claim or my report does not cover anything legal. Whether the termination was legal, whether it was rightful or wrongful, that is for something like Raj or Vyapak to determine. I mean, they are the lawyers. They would determine whether it is a lawful termination, whether it is an illegal termination. Our role starts if it is an illegal termination, and if the law says that if the facts of the matter, of the facts of the case say that it is an illegal thing, then what is the loss which has been suffered by the counterparty? So here we had a very, very strong case where we had when Deccan Chargers was cancelled, there was subsequent auctions where Hyderabad was sold, Pune was sold, Kochi, that there were 3 IPL teams were sold. There were 2 failed auctions and bids. So it was not, we had a wealth of data where there were subsequent transactions, there were prior transactions to support a view. And therefore it was quite and we could build around all the transaction data to prove that, see, there is this evidence. It is not a figment of my imagination. It is a DCF or the cash flow valuation that you can do could be considered. It is more difficult to defend because it is often considered a figment of imagination. You could come to any number that you wish. But having so, if your opinion is backed by real evidence from the market, and that is the case we had where we had Pune, Kochi, Hyderabad itself getting auctioned again, and we had 2 failed bids on the same franchise. So we had a strong data point, and we were able to convince the jury and the judge and the lawyers on the both sides that this is a fair thing to do. So some of these things have to be done. So as I said, it has to be a speaking report. It cannot be the report. Once someone reads it, he should be broadly be convinced that yes, there is an application of logic, while assumptions could change, and with the same data point, someone else can put a different number to the damages. But if we are logically consistent, then broadly the other side would also see merit in what we are saying. That's my opinion. But that
Sure.
that was one. So in that sense, it was one of the few ones where the matter, in a very short span of time, started with the trial, and we went to the damage assessment and cross-examination stages and multiple stages of cross-examination, and finally we were able to see it through. One more angle there is that the expert has to be very well prepared for the fact that there will be army of lawyers from the other side who will be gunning for his credibility. They will be gunning for his every word that he says or he fails to say. So he has to naturally do his job meticulously well, and he has to ensure that it is his reputation online. Sometimes if he is inconsistent, not just in this case, but in some other case that he has done, and if his inconsistency or some wrong observations are sometimes proved in a Delhi or Calcutta or Hyderabad High Court, then even those can be brought out by the lawyers to say that, see, this witness, he did something wrong in that case, so he is not a reliable witness or something like that. So one has to be careful about that. So this is my practical take on things. If you want to add something, your thoughts on that?
No, I think you perfectly covered it, Rajiv. So in terms of expert witness and what Vyapak also said in terms of independence, credibility, thoroughness, I mean, all these are nothing but at the end of the day cornerstones of any professional exercise, if you look at from a wide perspective.
Yeah, and the importance is seen as you rightly, I think, let the participants think about IPL in these days is always good. I think people are waiting for the new IPL season to come in, but the kind of damages which are granted shows that if you have the right expert and right calculations, right, these days the arbitrators or judges are not shying away in granting those damages, and this is now time and again seen, whether you talk about the celebrated cases like Tata Docomo, where more than $1 billion damages were granted on just an exit option which was not adhered to, and then you also have Daiichi Renbexi, where for a misrepresentation claim, more than 4,500 crore claim was not only granted but approved by Indian courts.
Yes.
Even before it was set, the set aside proceedings in the Singapore were taken. So that's the kind of strengths you gain by the correct calculation, and Indian courts and the arbitrators are no way going to reject, even if they look high as a first instance. So that's I think that's the importance that answers Rachna's question in a very simple way, that you can really take care of those losses if you have the right expert.
Sure. I would want to bring in Ravishu in this conversation about your experience, dealing with specific cases of joint venture disputes or maybe family settlements. How different these disputes would be, and in terms not just of quantifications, but in terms of your approach towards the quantification.
Sure, Rachna. Joint venture valuations, especially in case of disputes or valuation for family settlement, are almost always challenging ones. Both the parties have their different perspectives, and they could be at a significant variance from each other.
Considering that is a emotion also that is invested into it.
Significantly, I mean, much more in case of a family settlement. You have so many other undercurrents other than the monetary considerations, which play a dominant role. If I were to look from a joint venture perspective, in most of the cases, the agreements will provide for some sort of a mechanism in case of an appointment of valuers or a dual valuers or an arbitrator or a mediator. Having said that, I mean, broadly, there are two sets of provisions. Either you have two valuers which are separately appointed by each of the parties, or a single valuer which is appointed jointly by both the parties. And I've gone through both the situations where there are two valuers which are appointed by both the parties. Invariably, you will require a third valuer because the value outcome of both the valuers would be significantly different from each other. Even though they inherently rely on a similar set of data, we had a situation where there were two joint venture partners, and the company was professionally run company. And the company had provided all the information. So while the JV partners had given the perspective, the independent management had given the projections and the views and the data. And the variance which was there between the valuers were X and 3X.
And where did you step into this situation?
Yeah. And
you 3X.
X. So we were on the 3X side. To be fair, at a few years down the line, it did got listed at a much higher than 3X. So if it's a single valuer, then the life becomes much more difficult because the views would be significantly different, and as a valuer, you will have to take an independent perspective and a reasonable judgment in terms of balancing the views of either parties. And in that particular case, you'll end up displeasing both the parties for sure, and maybe that's a test of fairness, because at the end of the day, both the parties would be aggrieved, though you would have done a fair job. So family settlement, I mean, it would be similar in that sense in terms of the underlying motives, differing perspective. But other undercurrents in terms of the emotions, past behavior, I mean, they do matter for nothing else, but from a party's individual perspective. And in those kind of cases, having a trusted mediator or a trusted arbitrator who can enforce his decision on both the sets of parties or multiple sets of parties is very important. Because we have seen the family settlements which goes on for years, and at the end of the day, the lengthy, I mean, the more the lengthy period, you end up destroying the value of the underlying, which obviously, I mean, it's a loss to both the sides. So having a good mediator, good arbitrator, trusted by both the parties, who can enforce his opinion on both of them, it's very important in my view. Other thing, in case of a family settlement, having a good M&A advisor, tax advisor, is also very important, because over there you will need to move parcels. I mean, the pieces enters the family, the group of family members, and the tax plays a large consideration over there. So that's my broad thought on JV and family settlements. Anything else you would wish to add, Rajiv, on this?
No, I agree with you. It is often, as you said, that when it is a family settlement, when often the best value or the best price at which they should settle, that where you would probably displease both the parties, and at that price, either one should be willing to buy or sell. So that makes the whole transaction sort of a neutral transaction. But achieving that is a very utopian number where you would have both the parties being, and often we need lawyers or mediators like Raj or Vyapak to be able to convince and mediate both the sides of parties. And often there is I mean, in India that does not, but this whole concept of hot tubbing, Vyapak, we would have experts on both the sides trying to come together, agreeing and figuring out a midway solution. When it is not just the lawyers, it is a
Possibly we.
Yeah, sorry. Yes, you would like to add there the concept of the hot tubbing, which is maybe not so far not happening much in India.
Sure. While the concept looks very, hot and attractive, the process is very, very mundane and I would say very challenging, and therefore one should not go with the name. But I think it is definitely very effective. We have seen where there are sophisticated adjudicators or arbitrators, because a large part of work which a counsel would do by cross-examining a witness, a fact witness on financials, and trying to sabotage the credibility and all of that, a large part of that work goes away. What remains is the narrow scope, right? Where both the experts are not agreeing to. And then there are, predetermined questions, or at least there is some broad cross-examination or questions from the tribunal which goes to both the experts. So I think the process is very, very challenging. You can't have two experts having the same view, and therefore it is very difficult to narrow down the difference of opinions between two experts. But what hot tubbing naturally does is takes away things which are in common, where both the parties are agreeing to. uh, it focuses on the nuanced differences that both the experts are trying to make, and then it allows the arbitrator and the counsels to ask those questions or understand the difference of that opinion and come to a conclusion that which is the most reasonable or the most possible view in the given facts and circumstances. But it cuts down a lot of flesh and lot of time, which unnecessarily goes into proving issues on credibility or things which are in common or things which are not relevant and things like that. So it's very efficient and effective way, so long as you have sophisticated tribunal to navigate through this process.
Sure. So moving to current times, Raj, a question for you. We all are in midst of a pandemic, and we as we are approaching towards normalcy, we would see a lot of claims that would get triggered, due to the current COVID scenario. What would be your thoughts, around existing contracts where, force majeure could get triggered, and the circumstances under which this could get triggered?
Yeah. So it's very important that whether first to understand what is a force majeure, and then to also look at your contracts and see, does your contract have a pandemic or an epidemic as a force majeure event? And therefore, it's very important to see every agreement very carefully, every clause very carefully about what is force. First of all, what is force majeure? Something that becomes impossible to perform in general terms. But whether pandemic or an epidemic is a force majeure is provided for in your contract, whether in your agreement the definition of force majeure includes pandemic or epidemic, because sometimes you'll get clauses which are rather inclusive, which would have a wide range covering itself, so which would also include probably the effect of pandemic and epidemic. So therefore, you have to carefully read your clauses. Having said that, all your claims on force majeure would depend upon your contract. Second, whether are you really impacted by it? Could you have carried on your work even during the force majeure period? Have you given your notice for force majeure on time? These are very, very practical requirements that need to be considered, because if you are invoking force majeure, have you issued your force majeure notice saying that I have suffered the force majeure event? Now, force majeure, whether it's continuing force majeure, there is a period of force majeure, because certain clauses provide that if force majeure continues beyond a particular period, the contract can be terminated. Now, whether your contracts provide for this kind of a time frame, if it does not, then you have to look at it differently. A lot of times you will see in say, for instance, in an infrastructure contract, Now, could you have completed your work during this lockdown period? Were infrastructure work exempted from lockdown? Because while there was a complete lockdown for a period of certain days, but subsequently there were notifications from the government which exempted infrastructure.
Right.
So with falling within the exemptions. Say for instance, you are a company working in an essential commodity business. Now there is a claim, but if you are an essential commodity supplier and the lockdowns did not impact you, would you still say that yes, you are falling within the force majeure and there was an impact upon me? So these are very case specific that you need to look at, because you need to also look at the government guidelines that came in during this period. Certain sectors have, certain ministries have actually treated this event as a force majeure event and provided for concessions in their notifications that have come out. And especially in relation to government companies, we've seen a lot of government companies actually accepting it as a force majeure event. But it may not be so in relation to two private contractors. So these things will definitely have to be looked at very, very carefully. In an infrastructure project, I think the government is also in some ministries have also come out with saying that if there is a retention amount, pay certain amount of retention amount back to the contractor if the work has been completed. Don't levy penalties on bank guarantees, delaying submitting bank guarantees. So these are the things that you need to look at very, very carefully in present times, especially supply chain distribution network or an essential commodity business or a commercial contracts. We are seeing a lot of these. Similar, I'm sure, are also the cases that we are seeing in joint venture disputes, in private equity matters. If Vyapak wants to take some of those.
Sure. So I think broadly, I agree with Raj on the issues, but if I may make it more simpler to understand, right? I think force majeure is all about impossibility and not impracticality, right? Uh, just because of maybe pandemic may be force majeure for every other purpose, but if your contract doesn't become impossible to perform, but it just becomes impractical to perform, then you have no claim. So I think one has to be very, very careful while making those claims as to whether you are talking about commercial losses or impracticality of performance, or are you talking about impossibility of performance. And I always is very, very enamored by the way our contract act is written, because it's 1872, 150 years ago, but you have almost every answer which you face today in that act. And unlike UK, even impossibility has been enshrined in our act rather than rely upon a common law or a judgment. So there are two aspects under Contract Act that one has to see. One is your section 32, which is a contingent contract. Basically, whether an event has happened or can happen or not happen for the purposes of performance, and whether such a contract is part, or such a clause is part of your contract, that if certain things happen or if certain things don't happen, you will not perform the contract. And there also the words are very clear, which leads to the impossibility of performance. Of course, the remedies can be suspension, remedies can be delay, remedies can be extension of time, whatever may be the remedy. But if you fall under section 32, which is where you have a clause under the contract of such a contingency of a force majeure event happening or certain events not happening, then you rely upon 32 to call that contract void. And this applies to all sorts of contracts where Contract Act will apply. And the second and the most important is section 56, where it basically says that a contract after it is made becomes impossible, right, for a event or a reason which the person who has to perform cannot prevent or is unlawful, then such a contract is void and you don't have to perform such a contract. Such impossibility of actions or such impossibility of performance is not enshrined in many other statutory regimes in different jurisdictions. So I think one has to really fall under the narrow scope. Yes, people keep referring to the February order of MHA, or rather the Ministry of Finance, on saying this is force majeure, and people rely on moratorium, and people rely on saying government has said that don't pay the rent, or small and big claims come out of all those claims under force majeure. But uh, uh, sorry to say, but it's not going to be very easy to prove those events to claim non-performance. And I think Raj has covered some of the practical examples. Only other example that I can think of, in addition to infrastructure construction contracts and other things which Raj talked about, or Sale of Goods Act, is the contracts which are generally, part of a shareholders agreements or private equity arrangements or lending documents. Okay, lending documents may be slightly different because force majeure has a different connotation, but let me put it as shareholder agreements or private equity investments, which are very common in an Indian context, and I'm sure a lot of participants may be looking at it. Is the effect again on the business, because most of these contracts talk about exits at a certain valuation. So there may be situations where those exit dates have fall before March lockdown, during March lockdown, or even post March lockdown. I think the biggest difference would be, one, what is the cause of the breach or the non-performance under those contracts, and the date of valuation. Because if the date of valuation does not take into account the COVID situation, then you are pretty much out of the game. Or whether the post breach factors affect the valuation, because as Rajiv was talking about DCF, you take into account your future income, projected cash flows, and if some of these things, while they were unforeseen, but still are factual matter at the time when you are doing valuation, whether you will have to take into account those as well, which makes the claim drastically reduce compared to what you would expect based on financial projections made in a board meeting in January 2020. So I think those were the aspects, in my view, would make a big difference as we go along because of the COVID situations and claims coming out of it.
Just
Sure.
one point I think, just
And I
one
would
point
just
if I
want to
may.
extend this by another 10 minutes.
Yeah.
Yes, Raj.
Yeah, so the only thing that I just want to come in here is that if you're looking at taking refuge under Section 56 of the Contract Act and going down the frustration route, parties need to be very clear that that is an end of the road for that contract in that sense. And the threshold to establish 56 frustration is very, very high. So be very careful before invoking provisions of 56 and saying that we want to frustrate the contracts will eventually lead to termination, because then the relationships come to an end. Have the parties contemplated a situation that for this period of problems they want to permanently put down their contracts to an end? Because this may be short-term hurdle, maybe a renegotiation may be an option, but invoking 56 and then leading to a situation where the contracts have to be terminated is not probably what is they have contemplated in their business.
Sure. So Ravishu, taking cues from Vyapak and Raj, what do you think should be an overall impact on the value or the sum of damages, the magnitude of change that could happen due to COVID, and the change that you perceive in the damages assessment and quantification process?
First thing is that the complexities would significantly going into maybe a bit of a nitty-gritty, one would also need to appreciate whether the claim is for force majeure or damages or indemnity, because the extent of claim which parties would be making would be different under different categories. So force majeure might have its own limitations. Indemnity may be a more wider, as Vapak had mentioned it earlier. Damages would have its own set of limitations in terms of direct damages rather than the consequential damages. So the purpose under which you are, the purpose for which you are computing would be important. And going back in terms of then trying to analyze that what are the reasons for the incremental damages or the incremental loss, and whether that is fitting within the definition of direct damages, or if consequential damages are permitted, the duration of the loss, or what is the duration for which the incremental loss needs to be computed. Do we have a, can we foresee that this is the end of the duration, because the impact could be more than just from February or March till today. The impact could be for maybe another 6 months, another year, maybe more, depending on the nature of the industry in which the business is operating. Some of the businesses could have a much larger implication or a much longer time for recovery. So some of those nuances would need to be taken care of. But I mean, at a broader level, looking at the purpose under which you are claiming, what can be claimed, and what are the elements and the duration for which you would make the claim. So these are the broad principles which you would wish to keep it in mind. That's how I would look at it.
I would just
Rajiv, your thoughts?
Anything else you would wish to add, Rajiv, on this?
Just one more. There is there is often a very important element, which is a duty to mitigate. It is not while there is a breach happening, the counterparty, once they realize that there is a breach happening, whether the supply of some equipment or supply of materials and all, now there is a duty cast upon him also, that you are once you realize that the breach is happening, you are also expected to take a mitigative stand. And if this material is not available from this source, can it be available from other source? Can you do any alternative arrangements? And therefore, the damage is the difference between the two. It is not a very, very consequential, incidental, and all the possible losses which can happen, because the counterparty is also expected to mitigate. And any court would only grant damages which are after reasonable mitigative efforts. So it is not that it is a clean and open, like we had a power plant, I mean, not just COVID related, but I can give you an example where there was one party who was getting some equipment from, say, BHEL, and there was a delay in supply of that equipment. Now, by that delay happened, and everything got delayed, by virtue of which a power purchase agreement got terminated. So that doesn't mean that the one party is entitled to the whole value of power plant. I mean, he could have gone somewhere else and got a turbine from Germany or some other place. I mean, what maximum he was entitled to was the difference between that. Now, we cannot claim the whole value of power plant because of that. So mitigation and duty of mitigation is also very critical. And all experts need to understand that while putting up a claim, because otherwise courts will just throw it out, because they can create a figment of imagination based on what everything could have happened, consequential, incidental to an event happening. That's my thing.
Sure. I think we have come to the close. Just if we could take maybe one question. So there's a question that has come from the participant. In case of damages or indemnity claim, how does the law of limitation work? How far back can the computation go? And is there a time limitation there? So Vyapak, Raj, would you want to address that question?
I think that possibly two different questions there, but if I understand it right, see, the law of limitation simpliciter is 3 years, which means from the date you have or there is a breach committed and you have suffered a loss, you can claim that loss within 3 years of that time. If you are asking how far back your computation goes, that depends upon the kind of loss. There is no limit of going back or going forward, so long as it is in reference and relation to the breach which has, let's say, committed in, you know, 1st January 2020, then you can claim that anytime within 3 years of that point in time. But if it relates to something which has happened earlier but the breach got later, there is no time limitation in that form. So if I understand the question right, that's the answer.
Sure, I think we are almost out of time. Any closing comments, Rajiv, Ravishu, Raj, Vyapak?
No, I think only closing comment is, I think we had a few more things that we wanted to talk, and obviously there are a few questions which we could not address. So we should, apologize for that and see if we can answer those questions offline. So maybe Rachna, if you want to take some of those questions, and if we can answer some of the participants, that would be good. Or if we can do a follow-up webinar, that is also fine by me. But thanks again. Thank you, RBSA, for holding such an important topic as a webinar, and always happy to collaborate with you all. Thank you.
Any thoughts, Raj? Any thoughts?
So, no, I just want to thank RBSA, Rajiv, you, Rachna, Rishu for having us. I think it's a very important concept of getting an expert on board now. It's been slow to pick up in India, but I think time has come that we see more and more experts in the disputes that are going on in India, because the role of expert really helps even the lawyers to build their case and put the case in a manner which can be easily acceptable by courts. The quantification becomes easier for us as well, because we are lawyers. We probably help frame the arguments and all of that, but sometimes we may also feel that if there is a help from a good expert who can assist us in building a claim, which can eventually be tested before or before the court, it really helps. I think its time has come for having experts on most of your big ticket arbitrations for sure. Thank you.
No major closing comments from my side, but I think I agree with you. I mean, as things are getting more and more, commercial disputes are coming up, joint venture disputes, family settlements, minority shareholder issues. The question where there is a need for financial experts as well as lawyers to work together, and there is a lot, and this is a different industry altogether. So while there is a significant need to collaborate with the law firms and the lawyers and the counsel, which is a different approach altogether, and as the litigation landscape, arbitration landscape is maturing and getting faster and quicker, God willing, then yeah, things will fall in place. And but again, not just in India. I believe there is a lot of action happening in Singapore International Court of Arbitration. There's a action happening in London Court of Arbitration, and therefore it is. And many of these are Indian cases being litigated outside India, and there would be a requirement for ascertaining all these things. So I think this is a good thing that we could organize. And Ravishu, any closing comments from us?
No, I think the panelists have covered it well. If you look at financial experts, it is certainly going to it's increasing. The stakes are quite a bit high, and what matters at the end of the day is the independence, industry knowledge, business knowledge, and being thorough with the work which you are doing. I think that's all.
Right.
And thank
So
you very
as
much, Vyapak and Raj, for being on the show.
Thank you. Thank you for having
Yeah,
us.
Rachna.
Thank you, Raj. Thank you, Vyapak. Thank you, Rachna.
As we come to the close of this webinar, for all the attendees' questions that we could not answer, please feel free to write to us at events@rbsa.in. The video recording of this event shall be available on RBSA YouTube page alongside our past events. I would heartily want to thank Raj and Vyapak, Ravishu and Rajiv for bringing a lot of eloquence to the otherwise complex topic today. So thank you all the panelists and thank you to all the participants for being a part of this webinar. Hope you all enjoyed as much as we enjoyed doing it. Thank you, everybody.
Thank you.
Thank you.
Thank you.